Hello from the Dukascopy TV studio in Geneva. We are covering the topic of the Supreme Court's decision in Switzerland and how it affects bank employee data protection with Mr. Alexander Troller. He is a partner of Lalive, international law firm in Geneva and Zurich. Mr. Troller, welcome to the studio. So on January the 12th, the Federal Supreme Court ruled on the communication of personal data to the US Department of Justice. And this has important implications. Can you outline the key outcomes and recent developments in this field?
Yes, absolutely. This matter relates to a bank that is a so-called Category 1 bank. In other words, this is a bank that was already targeted and prosecuted by the Department of Justice when the so-called US program for Swiss bank came into play. And it is not one of the 100 and plus Swiss banks that now participates in the so-called program. Nevertheless, it was also confronted with the requirement to communicate certain employee data to the US. And what this bank did is that with the authorization of the Swiss government, it legally communicated the identity of several employees that were handling US customers to the US Department of Justice. Now, two of these employees requested access to their data in order to check what the bank had exactly communicated to the US authorities. The bank allowed them to consult the data at the bank's premises, but not to take copies of the documents that had been handed over to the US authorities. So the very question at stake was whether the former employees had a right to obtain a copy of the documents that had been sent to the US, or whether they were merely allowed to consult the documents at the bank's premises but without taking copies. And what also has to be noted in this context is that the Swiss Federal Data Protection Commissioner, in other words, a governmental authority, had not ruled but opined beforehand that former bank employees or current bank employees were entitled to consult this type of information, but not to obtain a copy in the form of a document of the information as it had been sent to the US authorities. This is the background of the case. The two employees did not satisfy themselves with the decision of the bank and took the matter to court, asking the court to order the bank, their former employer, to give them a copy of what had been sent to the US. The bank objected to the requests of the employees on primarily two grounds. The first one being banking secrecy, in other words, that there was a risk that the identity of clients of the bank might be rendered public if the bank were to disclose this information, these documents, to their former employee. And the second one being an overriding interest of the bank not to communicate documents that could include commercial secrets of the bank or information that was otherwise privileged or confidential of the bank. The matter landed before the Geneva Court of First Instance, who ruled that, first of all, the bank could not object banking secrecy because the information could be redacted or could have been redacted in the sense that, and in fact it had been redacted in the sense that the name of clients did not need to be communicated to the former employees. So the name of the clients that these employees had been entrusted with while they were at the bank could be deleted from the document. And on the other hand, the employees were still under a continued duty of confidentiality to their former employer, which means that notwithstanding the fact that they probably even remembered the name of former customers, they were legally prevented from disclosing them. So this objection of the bank was not accepted by the court. And the court was not friendlier to the bank on the second argument either, being the overriding interest of the bank to protect its own commercial secret. What the court ruled in this matter is that the bank had not demonstrated that it was at risk of seeing its own commercial confidential information being disclosed by the former employees who had not hinted at the fact that they would go public with any secret of the bank itself, as opposed to client secrets. And this is why the Geneva First Instance Court ruled in favor of the employees, decided that they had a right to obtain a copy of the documents. This decision was confirmed by the Geneva Court of Appeal. The bank took the matter to the Swiss Supreme Court, who then confirmed the former Geneva cantonal decisions.
So what implications does this decision now have, and where do we stand in the development of communication data to foreign tax authorities?
If we take it in the context of the US program for Swiss banks and, well, 106 or maybe today slightly less banks that do participate in this program, this decision has an impact on them as well. Although in the case that was ruled upon, it was a so-called Category 1 bank, this case now also applies to all Category 2 banks. In other words, former employees or current employees who see their data and identity communicated to the US authorities, as it happens in the framework of this program, have a right to obtain a written copy of the documents that are being sent. The rationale being that they need to be able to check the accuracy of these documents, and also that they have a right to prepare their defense should they be targeted, prosecuted by the US authorities, or possibly to act against their former employer in the event that the information communicated is not accurate.
And what challenges remain in this field, and what developments are to come?
The developments to come are, at least on the merits, the situation is now that several former employees or third party asset managers, finders, have objected to the communication of their data primarily by Category 2 banks to the US and have gone to court. Most of them, at least in Geneva, have obtained provisional measures or interim injunctions preventing the banks from communicating these data to the US. Now, these are not final decisions, but they need to be confirmed now through legal proceedings. And it will take several months, probably, before there are final decisions in this matter by Swiss courts on whether the information as such of these employees has to be communicated or not. But at least they will be able to, let's say, have their appeal supported by written documentation and be able to show what type of document is to be communicated or not to the US. What the challenges that remain are the so-called borderline cases. In this matter, the Swiss courts ruled that the bank did not demonstrate that it had that it was at jeopardy of seeing commercial secrets of the bank being communicated to the employees. The courts, however, reserved the demonstration by the bank of such a case. So there could be cases where a bank may successfully argue that by allowing an employee to obtain a copy of a certain document naming the employee, it is also disclosing commercial secrets of the bank. And there could be an argument over what needs to be redacted or not on the relevant document.
Alexander Troller from Lalive, thank you very much for explaining this complicated situation to our viewers.
Thank you.
And thanks for watching. Do make sure to keep clicking back on the Dukascopy TV website for latest updates and exclusive interviews. Have a great day and see you next time.